So let's go ahead and get started. So online platforms, we know that they're popular. Everybody has seen them. What should you be aware of? So we're going to start out with who is right for online planning. I mean, is your situation the correct kind of situation? So sometimes it's easier to start out with saying, well, who is not right for an online planning situation? First of all, are you married? That might be a situation where online planning is not right for you because there is so much that goes into planning for married persons. Do you have minor children? If you have minor children, again, if you don't get the right estate planning advice, you could be putting your kids at risk if something happens to you. Are you in a blended family? Blended families are really a situation where there could be problems if you do online estate planning. So what you can see, what I'm saying is, here are the people that might need more than just online planning because their situation is more complicated. What's the amount and level of your assets? If you have modest assets, you're more likely to be okay with online estate planning. If you have complicated assets in more than one state, if they're a higher level of assets, then you might want to get professional guidance. Who are your intended beneficiaries and what is your relationship with them? Do you have a special needs child or a special needs person who would be inheriting from you? Or do you have somebody who will inherit from you and they do need some sort of asset protection? For example, they couldn't manage their own money, they shouldn't manage their own money. They might be getting government benefits. If they inherit, they will lose all of their benefits. If so, again, online might not be right for you. Do you want some level of control after you're gone? In that perhaps you want to make sure your child inherits, but not your child and a divorcing spouse of your child, not an in-law. What about if you know your family dynamics are problematic, such that if you don't do everything perfectly right, then there could be litigation or problems. So all of these situations are situations where think twice about online estate planning. Yes, you can do cheap, do-it-yourself online estate planning, even in those situations, but the result might mean costs and litigation or problems that your family goes through, or loss of government benefits. This is what I'm talking about. What are the consequences of not getting good estate planning counsel up front? We will talk about, I mentioned married couples. I do want to mention, when I say asset protection for married couples, and remember, I'm coming to you talking from the state of Washington. In Washington, our laws are really clear that if you want to protect assets for your spouse when you're gone against any kind of spend down for long-term care costs, the only way you can do it is through a will. Yes, you can buy an online will, but no, an online will not have the correct type of trust in it to protect assets for your spouse. And that's why I said that if you are married, and especially if you're interested in asset protection, online planning might be a real disservice for you. You might want to see a lawyer. Along those lines, if you are a retiree, again, this goes back to asset protection. People who are retired, generally they're older. Generally, folks who are older may have concerns about protecting assets that they have against long-term care costs, not just for their spouse, but maybe for themselves. Part of online estate planning is not just a will, but probably a durable power of attorney, because everybody needs a durable power of attorney no matter what, one for finances and one for health or medical. So if you do an online durable power of attorney, and let's say something happens to you in the future, you want to protect assets for yourself so that everything you worked for all your life doesn't have to be spent down on your long-term care costs. Would you be able to do any kind of Medicaid planning? Well, if you're incapacitated and you have an online durable power of attorney, one that doesn't grant the necessary authorities for your attorney in fact, your POA, to do the kind of planning that needs to be done, then no, you won't be able to do any type of Medicaid strategies. That means all of your assets will be spent on long-term care. So retirees are folks that I really encourage to speak with an attorney, an elder law attorney that knows Medicaid asset preservation strategies. Takeaway on that was all of those folks think twice about doing online. So who is online possibly okay for? Who might it work for? Are you single? Do you have no minor children? You can have kids, just not minors. Are your assets fairly simple and modest? If that's the situation, then online estate planning might work for you. One of the things that you don't get from online estate planning though is, let's say you fit that bill. You're single, you have no minor kids, you haven't been divorced, at least not recently. It's been ages ago, so you're not worried about your divorcing spouse claiming anything. You have modest assets. And so you think, well, let's just do an online estate plan. What might not happen is that you might not become aware of estate planning strategies that would allow your estate to be administered simply upon your death. So, for example, if you do a will takes effect upon your death. What do I mean it takes effect? Well, that's when your will needs to be probated. Probate is an expense that an online estate planning form will not help you with. So if you're doing an online estate plan for cheap, then you are deferring the expenses of administering your estate until after you've died. So you do want to make sure that you have money set aside to help with the probate of your estate. So let's say you're single, you do an online will, and you own a house, and you just want everything to go to your child or your two kids equally. And so you fill out the online form. Had you come to an estate planning attorney such as myself, I might have suggested to you, well, of course you do need a will, but let's make sure you avoid probate because we don't want to have an unnecessary probate upon your death. Let's go ahead and do a transfer on death deed on your house. And if you do that, you will then avoid the costs of a probate when you die. If we get it set up right, then yes, you pay costs to the attorney when you set up your estate plan, but upon your death, there's virtually no costs. Whereas if you did it on an online platform without getting guidance and counsel, then yeah, it was cheap up front, but there will be significantly more costs on your death. And so that's the kind of situation where, with online forms, you might get a perfectly correct form for the state you're in, but you will not get guidance as to, well, what does that mean for the rest of your life and for upon your death? Kind of the takeaway is a single person with modest assets, no minor children, may be appropriate for an online type estate planning package. And then now what we're going to do is we will get into, okay, so what should you be looking for then if you're doing an online package? Question, is the takeaway that everyone is better suited to do a consult with an attorney, even if they qualify for doing online forms? Yes. Yeah, that really is the takeaway. And granted, I'm an estate planning attorney. What I do is I help guide people. So I know that if you were to talk with me or another estate planning lawyer, you're going to get advice. Whereas even if you do one of those online form packages, I think there's packages that you can buy for $500, and it includes a consultation with an attorney. I think you have to question, what are you really getting for that $500? Are you really getting somebody who is going to take the time needed to know your situation and give you the right plan? Or are you just going to get a cookie cutter package that is what is sold with all of those plans? Let's move on to, okay, let's say you have decided, or at least you're interested in doing the online planning. So if that's the route you're going to take, then what do you need to know to have your best opportunity at doing it right. Number one, make sure that the forms that you are using are state-specific forms. And what I mean by that is if you live in Illinois, for example, you are not going to want to have a form filled out that says Washington or Washington law. That's kind of a obvious situation, an obvious problem. But do make sure that when you fill out the forms that they are appropriate for your state. One of the things I wanted to mention though is any legal document that is filled out correctly in one state will be honored theoretically, legally in another state. That means that, if you fill it out in Washington, for example, you filled out the right Washington form, you put in Washington law, Washington, everything specific. You filled it out. And then what happens? Let's say you move to a different state. In Washington, our probates are really simple. So typically estate planning done in Washington is based on last wills as opposed to revocable living trusts for a lot of reasons. Our probates are simple here. There's a lot of problems with revocable living trusts if they're not administered correctly. So let's say you fill out your online form and under the laws of Washington, and it's all done correctly, and then you move to California, for example. So when you move to California, your Washington forms filled out correctly here will be legally enforceable in California. Will that be the right plan for you in California? So every state has its own different version of what durable powers of attorney look like. So your durable power of attorney might be legally effective in California, but there might be difficulty in having it accepted by a financial institution. More importantly, your Washington will work fine here in Washington, and in California, it will be recognized, it will be honored. But in California, probates are extremely expensive. They're based on a percentage of the value of your estate. And that's why in California, because probate is so expensive, if you don't visit an estate planning lawyer and don't create a different kind of estate plan, for example, like a revocable living trust-based plan in California, then the result is going to be a lot of costs for your estate when you have passed on. So it may be technically legal enforceable in one state, an online form, but it might be a terrible plan in a different state. And how do you know that? You don't know that unless you talk to an attorney. All right. Second, do-it-yourself pitfall is that you assume that your will covers all of your assets. And it comes to as a surprise to a lot of people that your will does not cover all your assets. Your will controls only those assets that pass under your will. So then that leads to the question, well, what doesn't pass under your will? And this is something that is not explained in online forms. So I really want you to be aware of this. What doesn't go under your will? So think of your life insurance policy if you have it. It probably pays to whomever you want it to pay to. So you have what's called a beneficiary designation on your life insurance policy. How about your IRA, your IRA, your 401k? That is going to pay again to whomever you've designated on the beneficiary designation form. It doesn't go under your will because there's a separate direction attached to that asset that says where the asset goes. Your joint bank account. Let's say that you set up a joint bank account. Let's say you're mom and you put one of your two kids on your bank account just to make things easier, and you set it up as joint tenants with right of survivorship. So then does that bank account go under your will to your two kids like your will says? It does not. It goes to that joint owner. And what happens when the one child who's on the bank account then inherits that account because you passed away, now it's theirs, are they going to share it with their sibling? Well, you hope so, maybe not. It really depends on a lot of situations. Maybe that kid that's the joint owner with you is going through a divorce or has a creditor situation. Maybe that money, through no intention of that joint owner, just doesn't go to both of your kids because of some threat to your child who is the joint owner of the account. So that's just an example of what you need to be aware of. So you need to be aware that your will does not cover all your assets, and it certainly doesn't cover some of people's biggest assets, which is their retirement accounts. So let's talk about, there's some details that I kind of wanted to get in. Let's say you do your will first, and then your will says, everything goes to my 2 kids. And then you do this later on, you do a joint bank account and you put your daughter on it. Again, that will is not going to work. It is not going to cover that joint bank account asset with your daughter. And then it's going to be uncertain whether your other child is going to inherit from you. I earlier had mentioned a transfer on death deed, and I wanted to kind of circle back to that. A transfer on death deed is a way to avoid probate on your death. If you want your real property to pass to someone, you do what's called a transfer on death deed. So let's say that you have a will and it says that your property goes to everything you have goes to your 2 kids. And then later you do a transfer on death deed to your daughter. Well, the daughter is going to get whatever you said, that whatever real property, it's going to go to her and not to your 2 kids. Let's say you do a later will. You have a transfer on death deed that goes to your daughter, and then you change your mind and you say, oh, I really want that property to go to my 2 kids. So if you do that, well, what's the outcome going to be? The will is later. Doesn't the will then take control of or supersede the transfer on death deed? No, it doesn't. So even though it was your intention and you did estate planning in an online form later, after the transfer on death deed, that transfer on death deed is still going to control. So how are you supposed to know that? That's where it gets difficult. That's where an estate planning attorney is going to help you out because they'll help advise you on that. And I can tell you that if you just do your Google research and you research transfer on death deed, you will find a form that's a transfer on death deed form. So everything I'm talking about with a will or a transfer on death deed, people can do on their own. But it's, what is not available online is the understanding of the interplay between these estate planning documents. The takeaway from this is don't assume that your will controls everything, because it does not. Okay, do it yourself. Pitfall number 3 is not saying everything that you need to say in your documents. In other words, not being specific and filling out the information completely. So when you fill out your estate planning documents, your will, your powers of attorney, there's a few things that you need to keep in mind. Number 1, you want to make sure that you use legal names. And I know that this sounds commonsensical, but for example, you're not going to want to say, Susie if her name is Suzanne. You want to fill out the full first name, middle name, and at least middle initial and last name, and do the full legal name for everyone who is going to inherit from you. What often people don't think through, let's say you fill out your will completely and it says that, your estate is going to go to these 3 children, 1, 2, 3, your 3 kids, and you fill out their names completely. Then what's the next step? What you need to think through is, well, what happens if 1 or more of those 3 children don't survive me? Where should their share go? So your online form may give you guidance. I hope it does. But let me explain to you what the options typically are that we see. Typically, if, for example, you say it goes to my 3 kids and your daughter doesn't survive, oftentimes people want the daughter's 1/3 share to go down to her children, to your grandchildren. And here in the state of Washington, we call that per stirpies. The other very common option that we see, though not as often, is that if the daughter doesn't survive, then her 1/3 share doesn't go down, but it gets divided between her 2 surviving siblings. So now instead of them each getting 1/3, they each get 50%. So if you're doing your forms yourself, really give some thought to, well, what if this happens? What if that happens? Where do I want to see my assets go? There should be forms and guidance to help you, but it's really important that you think through that. Another thing is, in terms of incomplete information and lack of specificity, sometimes people say, well, I don't want my child to inherit from me. So because they know they don't want their child to inherit, take the same situation. Mom has 3 kids and she only wants 2 to inherit, but not the 3rd. The law requires that you name all 3 children, even the one you do not want to inherit from you. Because what happens is if you fail to name that 3rd one and you say, I'm not going to name them because I don't want them to get anything. If you fail to name that 3rd child, then they will get 1/3 of your estate, because the law has an interesting concept that suggests that you forgot about your child. And so if you don't name your child, the law says, oh, must have forgot about the child, therefore they inherit 1/3, when really that's not what you wanted at all. So make sure, especially if you are disinheriting anyone who is your child, you need to name that child. Now, do you have to name other people you don't want to inherit from you? No. The only people that you must name in your will are your spouse and your kids. That way, those are the people who you must name. And so your spouse, your current spouse, and all your kids must be named, even the one you don't want to inherit from you. So make sure that you do that. And please, please, please do not say my disinherited child. Let's say you do name them, and I make no provision except for $1. Please don't say that they get $1. Why? Because if you give them $1, then they have rights under your will that they would not otherwise have. And your executor of your estate actually has to give them $1 and do work that's involved with giving that, $1 to the person that you wanted to get nothing. So it is not a good idea to give anybody $1. The idea with that is if you give somebody something, then they can't challenge the will. No, they can challenge the will. And you can expect that if you are disinheriting someone, online forms is probably not the way to go, because you're going to want to make sure that your estate is not going to be litigated by anybody. So kind of getting back to who is appropriate for online estate planning documents, not if you're disinheriting somebody. Definitely see an attorney in that situation. Number 4, do-it-yourself pitfall is not following formalities. Estate planning documents have to have formalities. So this is something that and I have seen these forms, even though the form might tell you exactly what you need to do, because it's not something people are familiar with, they often fail to follow the formalities. And if you fail to follow formalities in the estate planning documents, either is not good, it's not going to be enforceable, or there's going to be a lot of work involved after your death to make sure to get the necessary testimony in court to prove up your will. So every state has its own rules, its own will formalities. Durable powers of attorney have their own formalities about whether they need to be notarized, whether they need to be witnessed, all of those things. The estate planning document that has the most formalities is the will. So what does a will require? The will requires that the person signing it the testator, the testatrix, sign it in front of two witnesses who are not disqualified witnesses. They can't be anybody related to the testator by blood or marriage. They cannot be anybody who will or might inherit from the testator. They can't be any kind of interested person. So they have to be independent, objective people. So when you do a will signing, what you do is if I'm conducting it, I ask the person, is this your will? Yes, it is. And do you understand its contents? Yes, I do. And do you understand what is the nature and bounty of your estate? Who are the objects of your affection? Does this provide for your beneficiaries as you desire? Are you competent, not subject to undue influence? Are you of the age of majority? That means over the age of 18. And yes, 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 yes. And would you like, these two witnesses to be the witnesses to your will? Yes, I would. Then the testator starts signing. We actually generally have them initial each page so that pages can't be substituted out later. Testator signs it. The witnesses sign under the testator's signature. Is that all there is? No, there is a next step, and it is to make this will a self-proving will. Because if you don't do this next step, then what happens is on your death, the two witnesses have to either do an affidavit or come into court in some way and prove that your will was actually valid. So how a self-proving will works is those same two witnesses who were in the presence of the testator while they signed the will and each other's presence, their signature needs to be on an affidavit form that says kind of all the things that I just said about the testator asking them to witness it and appeared to be of the age of majority, understand the will, not under undue influence, etc. And then a notary public is the one who then notarizes the signature of the witnesses to the self-proving affidavit form, not to there's no notary of the testator's signature. So it's pretty confusing, and it's really interesting. Hold on. I was just looking at, an instruction for a self-proving affidavit that came with a form. It's a lawdepot.com form, and it's a very accurate instruction, but it wasn't done. And so why wasn't it done? Well, because people aren't lawyers, and you have to follow those directions to the detail. And so it is very, very common for people who do online wills or codicils to not follow the instructions. So as a result, what happens then when the instructions aren't followed? Number one, the will could be invalid. If the will is invalid, what that means is the laws of intestacy of the state come into play, and that might not at all be what the testator wanted. Or let's say that the will is valid, but the self-proving part wasn't done. In that event, then there has to be, a fairly significant amount of work to get those witnesses to testify as to the validity of the will. So again, this is kind of the penny wise, pound foolish part of doing online wills is, even if it's appropriate for the person, if you don't follow the formalities, then really you've created more of a mess, certainly than you ever intended to. So not following formalities, that is a big takeaway. And really, this next one, the do-it-yourself pitfall number 5, I think is the biggest one, because what it is if you do online forms, what are you missing out on? You're missing out on understanding what it means. You're missing out on sitting down and talking with somebody who is an expert, who understands estate planning, and who will and should take the time to know What is your situation? What are your family dynamics? What are your concerns? What are your goals? What do you want to make sure that is accomplished? Sometimes I think that people do the online forms just because it makes them, they know they've got to do something. But, outlay of, several $1,000s, which it could be for estate planning, really isn't either in the budget or, sometimes we often find that the reason people have so much money is they never spent any. So they got a whole lot of money, but they really don't want to spend it. So, it's completely understandable why people don't want to pay for professional services. And I think it's the people who have suffered the consequence of somebody not paying for professional services that are more likely to say, please make sure you talk to an estate planning lawyer, get the right estate plan in place to make it easier for your family, for your beneficiaries when you're gone. So how do you know that you've missed out on estate planning strategies? You might not know ever. At ELG Estate Planning at Elder Law Group, our expertise is not just in estate planning, but it's in asset protection. And asset protection, especially when it comes to long-term care costs and government benefits. So, very few people understand with any depth the area of practice that we do here, how you protect assets against long-term care costs so that you don't go broke, paying for the nursing home. What if people miss out on those kind of strategies? What happens, and we often have seen this, is that people just spend all their money until they're broke, or spend it down until they're close to broke and they go, this is scary. I'm scared of running out of money. I think I should go see a lawyer. Yes, they should go see a lawyer, but they should go see a lawyer well in advance of that situation happening. So that's when I was mentioning, right, retirees really aren't that appropriate for online estate planning. And that's because long-term care costs are the number one threat to their financial security. See a lawyer in advance. A Medicaid planning lawyer, an elder law attorney in advance. Because if you do that, then what we will likely set up is wills with asset protection, which guarantees that at least 50%, up to 100% of this couple's assets will be protected on the death of the first spouse. What does that mean? That means that the surviving spouse will never be destitute. They will never go broke. So those are the kind of legal strategies that folks miss out on if they don't go see an attorney. And what I just talked about was really specific to elder law. And if you are, especially if you are, not in Washington in this state and you're out of state and you're going, well, who's the elder law attorney that I should speak with? Go to NAELA.org. That's NAELA.org, NAELA.org. And type in your location and look for a NAELA attorney that's close to you. Now, being a member of NAELA doesn't guarantee that the person, is a great asset protection elder law attorney, but it certainly is a qualification that you want to look for. What else should you do? You should find out what are their qualifications. Look at their online reviews, look at information that they have on their website, etc., and then talk with them. And when you're looking, especially if you're concerned about long-term care costs, a lot of people say that they're elder law attorneys. There's nothing that prevents people from saying, hey, I'm an elder law attorney. So you need to ask the question, well, tell me, do you do Medicaid applications? And if they say no, then I would really question whether they understand the strategies needed in estate planning documents to protect assets and to, so that Medicaid eligibility is a possibility. So if you are going to hire an attorney, ask questions of whomever you are interested in hiring and make sure that they have depth of staff, depth of knowledge, and that they've got all the qualifications you need. Because just like online forms can lead to problems and mistakes, hiring the wrong lawyer can do that too. You really want somebody who's an expert in this area. Other online strategies that you're missing, there's a lot of them. I mentioned that, let's say you do a simple will. The plan may have been better to do a transfer on death deed and avoid a probate, and have a will as a backup, but do a transfer on death deed to avoid a probate. Maybe you do online planning that's a revocable living trust, or maybe you have a revocable living trust because everybody said, hey, that's a great way to avoid probate. Well, it might be appropriate or it might be a really bad idea. Will you know? Probably not until either there's a death or it's too late. With revocable living trusts, people understand that there has to be a deed put, taking your house from your name, put it into the name of the trustee of the trust, or that their bank accounts need to be retitled in the name of the trust. Or, there's a lot of things that go into understanding a revocable living trust. So certainly you can find online forms for it. But I think revocable living trusts are even more likely to not be successfully implemented through an online platform. When it comes to doing estate planning, it's really interesting. Is there any need to do estate planning? People can go through their whole lives and die, and they never did an estate plan. And I think that's one of the reasons that sometimes people just don't do an estate plan, because there's nothing that forces them to do it. So in that situation, what happens? Well, generally what happens is on their death, they have left a mess for whomever has to come clean up and take care of things. So usually people are more responsible than that. They kind of say, well, I don't want to, make so many problems for my loved ones when I'm gone. So what I'll do is I'll just do an online form. Is it going to work? Maybe, maybe not. It might work, or it might leave a mess. Consulting with a general practitioner, that's better than an online form. But somebody that can do multiple areas of law, I would really question whether they have the expertise to give you the right estate planning guidance. I know in our practice, this is all we do is estate planning and elder law with a focus on Medicaid. We don't do all these other practice areas, because I think that the day of the generalist really is over, it's gone. What's my recommendation? If nothing more, speak to an estate planning and elder law attorney. Tell them what your concerns are. Get their recommendations. Then it's up to you. You can choose to hire them, pay their fees, or not. At least then you'll have more information. We have people bring in their online forms, we review them, and then we explain to them why, that might not be the best plan for them. But we are providing information. Then it's up to you. You can make the decision. Is it okay what you have, or will you have more peace of mind if you make some changes and put into place an estate plan that has been recommended for you, for your situation, to make things easier for you during your life, for your loved ones when you're gone, and also to make sure that all the assets are protected and will go where you want them to go and won't go to legal fees or be spent unnecessarily. So no surprise, I think that the biggest problem with online planning is that you miss out on anybody going over the planning with you. It's really not planning, it's documents. Estate planning really is the guidance and counsel that you get from the attorney that you meet with. All right, so what's the takeaway? Yeah, online forms are very attractive because they're very inexpensive. Estate planning costs money. It's really what's important to you. What do you want to leave for your legacy, for your family? Whether or not, you see an attorney or not, I do want to let you know that if you click on the link, you will be able to get, or we will send it to you for those who attended via Zoom, an estate planning online checklist going over some of the things that we talked about. So that will help guide you. So click and download that form. And again, questions, we would be happy to help you here at ELG Estate Planning. Our website is elgwa.com. Our phone number is 509-468-0551. Thank you, everybody, so much for joining me. I really appreciate it today.